Good evening, everyone. I hope you're all doing well. Welcome back. Tonight we're doing chapter 7. We're going to talk about the creation and the termination of agency. So how is the agency actually created and how can it be terminated? We've gone over this some in previous lectures, but we're going to go into more detail today. So let's go ahead and get started. Our outline for this evening. We're going to go over how and when agency is created. We're going to go over expressed and implied agency, agency and transaction specific, ostensible agency, agency by ratification, and gratuitous agency. We're also going to go over some important issues, any legal effects, constructive or imputed notice, imputed knowledge, professional and ethical responsibility. We're also going to talk about how agency is terminated and the duties of agency that survive termination. What duties do you still have to give to your client even after your agency has been terminated? And that's our outline for the evening. We don't have a whole lot, but we're going to go in more detail. How you doing, Gio? What's going on, guys? So how and when is agency created? We talked about this before. It should be a mutual agreement. They should both agree. The client has to consent, and you have to consent to representing them. Like I just said, it requires consent and control. So in an agency situation, who is actually in control? Am I in control as the agent? Am I controlled, Travis? As the agent, am I in control of an agency relationship? No, the client's in control. Not even your broker is in control. The client is in control. So even if my client, say they decide that they want to accept an offer that's $100,000 less than what their property is actually worth, can I tell them no? Can I say no, you can't do that? Or do I have to actually say, yeah, you can do that?
Is this the point we're on?
Yeah, that's for tonight. So I can't, if they want to accept an offer that's $100,000 less than what their property's worth, I'm going to make less money, but I'm not looking after myself, I'm looking after them. So if they want to do that, they can do that, and I have to accept that. Let's say I have a client that's putting in too many lowball offers. We put in 10 contracts, and all 10 of them, he's only put half of what they're asking for it. What about in that situation? Can I say bye-bye to that client? Say you're wasting my time? Can I say that?
Yes.
Because you're here. I can say that?
Yes.
Okay, so I, as an agent, I cannot say that. That is actually the broker's prerogative. In that situation, I would say, hey, or I would tell my broker, hey, we're putting in a bunch of low offers, and in that situation, he would probably write that person an email saying, hey, I understand you're trying to save money, but we also have to make money, and you're wasting my agent's time. Are you actually going to be serious? He might send an email and say something like that. So no, I can't exactly say bye and just walk away. I would have to discuss that with my broker. But if my broker decides, yeah, I don't want to deal with this anymore either, or I don't want you dealing with this, then yeah, I could just walk away. And we're going to go over how it can be terminated in a little bit. That probably will happen. Sometimes you get a crazy client that's just, man, this client's out of their mind. Do I even need to spend any more time on this client? You know? We good?
Yeah.
So more on how an agency is created. So Trailer states that a broker who represents a party in a real estate transaction acts as that party's agent. So me, just because I am a real estate agent, that doesn't mean that I am the agent, if that makes sense. I am a sub-agent of the agent, and the agent would be the broker. So the Texas Real Estate License Act states that if I'm in a party and I represent someone, I am that party's agent. Also, while acting as an agent for another, the broker or salesperson acting for the broker is a fiduciary. And that just basically means that I am held in the highest standard, and that I owe a fiduciary duty. We've gone over fiduciary duties. I would owe that to my client. And that's when an agent is acting on behalf or acting as a salesperson for the broker. And remember, I told y'all before, what if, one of my clients, they want the same house that I want. My fiduciary duty, like I was saying, fiduciary, is to my client. So I couldn't put an offer in on that house, because if I did put an offer in on the house, I know what my client can pay. So I have an inside track on the deal, which gives me an unfair advantage, and that can also get you into some trouble as well. So your duty is to your client. I'm going to say that a million times probably throughout my teaching, but it's to your client, not to yourself. All right, some non-essential elements. This is actually a little bit of a diagram. So compensation, you technically don't need compensation for it to be a valid agency, but of course you do want to get paid for what you do, correct? You're also going to want it in writing. Like we said, pretty much everything in real estate needs to be in writing if you want it to be enforceable. And license, is this person actually qualified? Are they really legally qualified to represent this person? And then of course the contract. So you're going to need a contract underway for an agency. You don't, like I've been saying, you don't have to have a contract for it to be an agency, but it's just a good idea because it protects you and your client. So there's just some non-essential things as far as agency is concerned. But in Texas, it must be in writing. So in Texas, if you're wanting to sue for a commission, or if you're going to get paid, it needs to be in writing. Like I said, to the statute of frauds, everything must be in writing. And it gives you written permission to do certain things. We've talked about fiduciary duties and certain things that you can do. And in Texas, there's certain things that you can and cannot do when you are in agency relationship. So yeah, remember, it needs to be in writing if it's to be enforceable. And in Texas, it must be in writing. So written agency contract. The duties of an agent and principal, the expectations for compensation, and sufficient detail to protect both. So the duties of the agent and the principal, if the client won't sign an agency agreement, it's in that situation, I would say, my broker is requiring it. And then that technically it puts it on my broker. And he's even told me to say that. My broker is requiring it. Because then if the client complains to my broker's just going to be like, I'm just trying to follow Trek's rules, basically. So there's certain duties of the agent and principal. In expectations for compensation, you need to put who is getting compensated and how much, and also where is it coming from. If I'm representing a buyer, the buyer is not actually the one paying me, it's the seller. Generally, it's the seller. So you need to have expectations for any compensation that's going to be made. And then sufficient detail to protect both. So in the contract, there is actually going to be some, it's going to line out what you do, what you are going to do, and what your client needs to do. And then it's going to have some protection for both of you if something were to go wrong. There's plenty of, not laws, but what are they called? Terms in the contract that protect not just your client, but yourself as well. So that's what you'll need for a written agency contract. All right, we've gone over express and implied agency before. We're going to go over them once again, and we're also going to talk about ostensible agency, agency by ratification, and gratuitous agency. Yes, there is something called gratuitous agency. And we're going to go over that. So express agency, like we said before, it's clear, it's to the point, we both know our agency, and it was either written or orally translated to both parties. Implied agency, we talked about that as well. That is by my actions. If I show you a bunch of houses, it's implied that I'm your agent. So that would create an implied agency. Ostensible agency we'll go over in a minute. Agency by ratification. So basically that just means even though it's basically agency, even though you terminated your agent, if I were to be your agent and I was terminated by you, they still might owe me a commission if I was the procuring cause. If they say, we started a sale, I did most of the work, and then right before the client has to start shelling out some money, he says, all right, we don't need any more, I'm gonna cut you off. So he cuts me out of the deal and just goes straight to the seller.
Does that happen often?
Do what?
Does that happen often?
Oh yeah, people do it. They'll try and get you that way.
Yeah.
And it hasn't happened to me. I'm sure it's happened to, the longer you've been in this business, the more likely something like that's going to happen. Of course, Justin probably has a situation where that happened to him. But even though he cut me out of the deal, I was the one that did most of the work to get the deal done. So in that situation, I could still have an agency with them, and they could still owe me a commission regardless of if they cut me out or not.
That's why we have those contracts.
That's why we have the contracts. Remember I was saying they have stuff in there to protect you and your seller or your buyer. So that does happen.
Wait, I have a question though. Just sir, what about for like implied agency though? So like you said how like everything has to be written and documented.
Mm-hmm.
So what about implied agency if you only ever like imply like an agent? Like how is that gonna play out?
If you're an implied agent, you still are technically an agent. You don't owe them the same responsibilities that you would for an actual client. But implied agency, you would still, how do I say it?
I would think if you're implied, if they cut you out of the deal, you're probably not going to get anything. It's because there's no contract saying you did work for them. So even though you did some work for them, they could have just been like, well, we were talking. I thought he was just doing me a friendly gesture, and like you kind of don't have anything to stand on in that sense. But like that's why we always have those like buyer's reps and listing agreements. It's like in it says if you buy a house from anybody else other than me, in these counties that I work or whatever, I still get my commission. Even if you don't use me and use somebody else, or if you buy it without using me at all, like I am your agent. I've been doing all this work for you, so you will pay me commission on whatever you buy, even if you just suddenly call me and say, hey, I bought a house. I'm gonna say, okay, cool, where's my check? Because I'm entitled to my commission because the contract says so.
But what you worked for, like for the steps you've done up to that point?
No, I get 3%.
Oh, okay.
Yeah, that's the way the contract is kind of written out, is that I get 3% of. So if I go show you 15 houses and I had you sign a contract and then you tell me, oh, well, cool, well, I have a brother that is a real estate agent, so I'm just going to have him do it instead. But thanks for showing me all this stuff.
Oh, okay.
I still get my 3% commission even if you have your brother sign the paperwork for you because you signed a contract with me that says I get 3% of whatever you buy.
Okay.
So if you have just an implied agency, and your client decides they want to kick you out at the end, there's not much you can do.
Yeah.
So you technically you're still an agency, but you can't sue for any commission if they were to just say, hey, bye-bye, we're done with you. See you
I haven't had
later.
anybody kick me out at the end, but I've had many times that I'll go to somebody like 6 or 7 houses, and then I just stop hearing from them. And they just kind of
They'll just ghost
they
you.
just ghost me and disappear. And then I might message them back saying, hey, just haven't heard from you in a few weeks, wondering if you're still looking to buy a house, like I can run like a search for you. And they're like, oh, we actually just signed one yesterday. Thanks though. I'm like, all right, cool. And like,
That happens
if I
a lot.
yeah, and that's why I started now, where like when I go show you a house, I will make you sign a buyer's rights, because like I'm not gonna go. I mean, it's different if like it's 2 miles from my house and it's like, cool, I'll just go show you a house. Man, even if you don't get it from me, it's like you wasted 15, 20 minutes of my time, like not a big deal. I'm not gonna push that on you because I don't want to sound confrontational on like the first meeting. But if I'm driving out to Brenham to show you a house or something like that, like,
Oh, yeah.
I'm getting you to sign something because I'm driving. If you're spending 3 hours or 4 hours of my time, like you're gonna sign this paper.
And my gas.
Yeah, exactly.
So, I mean, that does happen quite a bit,
Yeah.
actually. I actually had one recently. It was just a lease client, but they ghosted me as well. Sometimes they'll do that. They'll ghost you. Which it's not as big as a hit if it's a lease, but if it's a buyer or a seller client, yeah, it's like, oh man, they just went behind you and did that.
Yeah.
And that does happen. I think gratuitous agency, we'll also go over that here in a little bit. So agency classifications, we're gonna go over express in agency again. Remember, it's clear, definite, explicit. We both know it's unmistakable that I am your agent, and you know that for a fact. So that's very clear. So the agent acquires direct authority once they enter an express agency. I have certain authorities that I'm given. It may be oral or written, but like we said, if you want to sue for a commission, put it in writing. If you want to get paid, put it in writing. So some examples of express agency would be like a listing contract or buyer representation contract. And also, so there's express and implied authority. There's a little bit of a difference there. So let's say, for example, I have a client that I just listed his property with. So I'm going to try and explain the difference between express and implied authority. So I have a client that I just listed one property with, but this client actually owns 10, 20 houses, and he's got several of those also up for list. But I'm not the agent for those. I just have a contract with him for the one property, say 123 Main Street. So if I go and I start showing his other properties and start pushing towards those properties, I could be trying to create an implied authority or an implied agency with him just by showing his properties and saying, hey, if I were to bring in a buyer, you owe me the 3%. So there's ways to create implied authority such as that, just by doing things, not even saying things, just by your actions. So implied agency we talked about. No express agreement has been made. It's created by actions or words. And to avoid implied agency, just disclose everything and verify. Just make it very clear that, hey, I'm representing this person in this transaction to all parties. Make sure it's clear to all parties who you actually represent. Remember, the agency is transaction specific. So disclosures must be made in each separate transaction. So if there's any new disclosures, like I was saying, if I had just the one property with him, but he has multiple other properties, there would be different disclosures for each property. It is grounds for to discipline you if a licensee fails to make it clear to all parties to a real estate transaction, the party for whom the license holder is acting. So in other words, if it's not clear to everyone who you represent in the party, TREC can actually take some disciplinary action on you, and they might take it out on your broker as well. So if Justin gets sued for something, who's he suing next?
You.
Me.
Yeah.
He's gonna come after me. So, and this usually is done in the very beginning to make it clear.
Carl has a question.
Do what?
Carl has a question.
Yes, sir. You got a question?
Yeah, I do have a question. So you just talked about implied agency, correct?
Yes, sir.
Okay, so and you just also mentioned about the track rules regarding okay, just what is it? Fails to make clear of all parties to a real estate transaction. So if it's on there, do you think implied agency would be good versus express, since implied is more indirect?
Yes. Generally, you're gonna want to do an express agency, not an implied. Like I said, usually an implied agency, you'll get into an implied agency usually by accident, just by doing your actions or your words, something you say or something you do for someone. But remember, I was saying implied agency,
Yeah.
you have no protection. So if you wanted to sue for your commission, you could not.
Okay.
So yes, you generally want an expressed agency, not an implied one. Does that answer your question?
Mhm. What happened? Sort of, but what happened if that ever coming to a point where it's you're doing implied agency? What do you usually do?
What do you mean? Like if you're doing implied agency
It's like
only?
a scenario. Yeah, let's say if just a scenario. Let's say if you're doing implied agency, then what do you do next? Like, do you continue doing it, or you just switch to express agency instead?
Generally, if I get into an implied agency, I'm gonna want to move it to express agency. So I'm gonna want to get a
Yeah.
contract, but it really just
Mhm.
depends on the situation. If you decide, hey, maybe I don't want to represent this person, and I only have an applied agency, it'd be much easier to get out of that agency than it would if I were to actually have a contract with them, if that makes sense.
Yeah,
So
because it feels like having implied agency just makes things more complicated.
it not only makes it more complicated, it also puts more liability on you and your broker.
Mhm.
Because like I said, if you don't have a contract, you don't have any protection for either you or the buyer. So if you're in an implied agency, you're just going to want to talk to your broker about that and decide, do I want to continue with this? And if I do want to continue with this, we should probably get a contract in just to help protect you.
Yeah,
Does that answer your question?
yeah, that answers my question.
So yeah, if you don't make it clear to all the parties, you can be disciplined by TREC. It depends on the situation as to how harshly they'll actually discipline you.
Mhm.
But yeah, if you don't make it clear, you can definitely have some disciplinary actions taken. All right, so ostensible agency. This is actually also called agency by estoppel. I think when I took the licensing exam, I didn't see ostensible agency at all. I do remember seeing agency by estoppel. So that might be the way that they're wording it in the test these days, is agent by estoppel. So it's ostensible, so for all appearances. So it appears that I am this person's agent. A court usually will prevent denial of agency. So if a third party assumes that I am the agent, then I'm the agent. If someone who's not even, in the transaction thinks that I am the agent, then that makes me the agent. So that would make an ostensible agency or an agency by estoppel. So Wilson and Dawes, that was a court case. That's where the buyer thought Wilson was the agent of Dawes, and they made decisions based on that presumption. So they did things in the contract based on the fact that this person was representing Dawes. So thus, Wilson ostensibly became the agent of that seller. So if someone, like I said, if someone thinks that you are the agent, then you're probably the agent at that point. And that is ostensible agency. Let's see, agency by ratification. So there's 4 elements of agency after the fact or agency by ratification. If the agent performs an unauthorized act. So basically, if I were to do something on behalf of my client without consulting them, like if I were to accept an offer for them, that could create an agency by ratification. So if the client subsequently learns of the unauthorized act that I did, and the client does not deny that I have authority to act, and also if the client benefits from the act, if all of these happen, then we have an agency by ratification. So if they do deny that I have authority in the situation, then in that case, it would be not an agency by ratification. So if they learn of the act, if they don't deny it and they benefit from it, then we have agency by ratification. Gratuitous agency. So gratuitous agency says the payment of fee does not necessarily determine agency. It's like I was saying, if I'm representing the buyer, who's paying my fee? Technically the seller, right? So I'm not his agent just because he's paying me. I'm the agent of the buyer. So be careful in the gratuitous agent when giving your opinion. As long as you're only stating facts, you should be fine. But yeah, you gotta be careful when you're actually giving your opinion in this situation. So courts will always follow the money. Of course, they're gonna go where the money is. And here's another court case. This is Kelly versus Rosales. The broker tried to claim that he was not responsible since the associate only doing a favor for a friend. So if I'm just listing this property for a friend, he could claim that I was not responsible or that I was responsible. The court held licensee performed negligently and therefore responsible even if no fee was collected. So even if I didn't collect a fee, I can still be held liable for it. But yes, you need to be very careful in giving your opinion. Sometimes you just need to state facts and leave your opinion to yourself. Sometimes that's just a good idea. All right, so important issues. So any legal effect, the agent stands in the client's shoes. Of course, you work for your agent, so you work for your client, so you are the client. You're standing in the client's shoes. Liability is based on your agency status, and the principal is liable for the agent's actions. So my client is actually liable for my actions But who are they actually going to blame if I do something wrong? They're going to blame the broker. And then, like I said, the broker's going to come after me after the fact. So your principal is actually liable for your actions because you are working under them. They are your boss. So I don't just have one boss, I have two, Mr. Nobles and my clients. So any constructive or imputed notice, there was a court case for that actually said notification of a subagent constitutes constructive notice to the subagent's client. So in other words, if I am notified of something, then my client is automatically notified of it, which is not always the case. I could be told something and then not tell my client. And then a few days later, closer to closing, your client finds out, and I said, I didn't tell you something. Technically, they would have to pay for the damages because I screwed up. Because technically, when they tell me, they've told my client too. So if I don't tell my client something that I know, he could end up paying for it. So yeah, like I said, anything that I am told, it automatically counts as being told to your client.
It counts as notice.
It counts as notice. So if they send me a contract, they don't actually have to tell my client that we sent a contract. As soon as they send the contract to me, it's considered that we've been notified. So you have to be really careful with that. Somebody have a question? No? Okay. So yeah, as soon as you learn anything, you're going to want to tell your client, pretty much. Just keep your client in the loop. If you end up not telling them something, it can come to bite you in the butt later on. All right, so any important issues, imputed knowledge, like I was just saying, client knows if the agent knows. So if I know something, the client should know it too, automatically. Any professional and ethical responsibility. Remember, the client is owed fiduciary duties. We talked about old car. And all parties are entitled to this. So all parties, even if you're not representing them, they're entitled to good faith, fairness, honesty, and accurate information and all material facts. Like we said, we were talking about the differences between customer and client. But even a customer is owed at least this right here. So basically. All right, now we're getting to actually terminating agency. So there's quite a few ways that you can actually terminate an agency. Of course, one would be time. You have to have a termination date on all contracts that are agency related. Because generally it's not going to take me, is it going to take me 5 years to find you a house? No, it shouldn't. I'm doing something wrong if it takes 5 years. Generally, a year to 2 years. That's generally what it is. And even though you're probably going to get them a house within that first year pretty quickly. But usually the agency will terminate when you close anyways. So you just put it out a year or 2 years because Texas and TRELA actually requires you to put in a termination date. It can also be terminated by actions of the principals or the agents. Things we do can terminate the agency. Or operation of law is a good one. So if any laws change, I think there's actually a new law that they're trying to do now is that no more than 2 unrelated people can live in the same house. Do you know? Do you know if that one actually passed or
I
not?
have no idea.
I think they're trying to do that right now, which would be pretty bad in a college town.
Oh, yeah.
Because there's a lot of houses or people that are renting out a bedroom in a 4-bedroom house. So there's already 4 people that aren't related renting out that house. So if the laws change, that can terminate an agency. I mean, what if I have an agency with a contract with a client that's selling their property, but then let's say the city changes the zoning of that area. What if they change that area to an agricultural area? Our contract would be terminated at that point because I'm not qualified for agriculture sales. So if something like that happens, or if they change a law, that can also that can terminate agency. Yeah, and I don't know if they actually.
Carl has.
Yes, sir.
All right, so I know you just mentioned about that new law that's about to be in effect. Um, so, so I guess in the future, people who are not related to each other can't own the same house.
Well, they can't rent in the same house, I believe. I don't know the exact details of the law, or if it's even actually going to go into effect. I know they were trying to.
Mm-hmm.
I don't know how far they got with it, but yeah, they're basically saying no more than two unrelated people can live in the same house at the same time.
So, so no house renting if that happens.
If that happens, it's gonna, yeah, a lot of the people that rent out to students are gonna be in a bit of a trouble because they can only rent out 2 rooms and they have 4 rooms.
Yeah.
They're gonna have to change. I mean, it won't hurt them too bad. They could always just change how much you were to pay and how many rooms you get, right? So if there's a 4-bedroom house, you could just say, or you pay, instead of paying $400 for your room, let's say you pay $800 and you get 2 rooms, and yeah, you're covered, you know, if that makes sense. But I still think it'll mess up a lot of the stuff we got going into college town if they do that law, especially to people that are renting out. Like I said, 4 rooms or more. So I don't know if I answered your question. That's one that I might not be able to answer, honestly, because I don't know what they're doing with it.
That's fine, as long as you know it's just something to think about.
If it does happen, I'll let you know. How about that?
Okay.
Okay. Yeah. So if the law changes or the zoning changes, something like that, it can lead to a termination of agency. Like I was saying, time, you have to have a time. Trailer requires a date, a termination date in the contract. You must have it. And here's a big one, may not automatically renew. I can't just go in and put in special provisions, automatically renews after a termination date. So that person is, anytime they want to buy a house, they got to come to me. And people used to do that, so they put in a law that you cannot automatically renew, because people were doing that. They were locking them into a contract, automatically renewing it. And so, you know, anytime in the future you want to buy a house, you have to go through me, and I'm getting a paycheck. So you have to have a termination date. You may not automatically renew, and reasonable time applies. Remember, I was saying it shouldn't take me 5 years to find you a house. Reasonable time, you know, like I was saying, a year to 2 years, 2 years max, I guess. So reasonable time periods apply as far as terminating agency time-wise. Terminating through the actions of the principals. So obviously, if we accomplish the agency objective, then it's terminated. We did what we set out to do. Our agency is terminated. Or the agency agreement has expired. You have to have a date in there. So if it expires, it's going to be terminated. Mutual rescission. And if we both decide, hey, I don't want to be your agent anymore, and you don't want me to be your agent, then we've terminated our agency. Revocation by the principal. That's where the agent pretty much fires you. Says, yeah, I don't want to work with you anymore. That would obviously terminate the agency. Renunciation by the agent. So if I renounce this client, like I said, I can't do that myself. I would have to talk to Justin, and if Justin agrees, yeah, let's cut this person off. And that would also terminate agency, or just straight abandonment by the agent. I just don't call, I just don't answer. That did happen as well. You probably get in some trouble for that one, but
Yeah, and from what I know, that's actually more there to protect the clients, not so much the agent. Basically saying that if I sign an agreement with you to be your agent, and then we work together for 2 weeks, and then I just don't call you anymore, you can go find another agent. And if you sign a contract in 2 months, I can't come up and be like, "Where's my paycheck?" Because they can claim that I abandoned them because I stopped talking to them. So that's actually there to protect the client, not to protect. It's not like the agent can just leave and that's good for them. It's basically saying if your agent abandons you, you have that is considered a termination, and you can move on and find somebody else.
Find someone else.
Yeah.
Yeah, so renouncing by the agent, abandonment by the agent, like you were saying, and any breach of fiduciary duty. If I breach any of my duties, the client can terminate immediately. They have the option to terminate. Operation of law for terminating agency. So if I or the broker dies or is incapacitated, if I'm a vegetable in the hospital, can I be your agent anymore? No, it would automatically release the agent. If there's a supervening law, so if a law comes into effect or a law that supersedes one law, that could lead to a termination. Or if I myself, if either the broker or the client goes bankrupt, or they're condemned, or if the property is destroyed, which would take a lot of effort, or just a nuclear missile or something.
Yeah.
But if the property is destroyed, we don't have any agency, we don't have a contract. So all of these are just more ways that it can be terminated. So all listings are under the broker's names. If something happens to the broker, we're pretty much all out. So we've been trying not to get our brokers sick.
And those first two don't actually count for the sales agent, the sales associate. That agent is the broker.
So it'd be the broker.
Yeah. So if I'm selling somebody's house and I die, the transaction actually isn't terminated. It Justin can pass it on to somebody else, basically. But if something happens to Justin, the whole brokerage basically falls apart at that point, and so then all the contracts are terminated there.
It's the same thing with the client, right? Like if your client dies and you're already in a contract, doesn't that fall onto their heirs?
If your client dies and you're already under contract, I'm pretty sure it'd be an automatic termination. There's no party for them to buy.
Yeah, I know me and Cody had like an hour-long discussion about this one day because it was a question from a practice test.
Oh, did you?
Yeah.
Yeah, and I don't really remember what the exact wording of it was. I think once we looked it up or talked to Justin about it, he clarified it, but I can't really remember what it was. But
I don't remember the answer that we got from it, but I do remember reading about that. And I think there was a test question on it where like if the client dies, then the contract is still enforceable, which doesn't, I don't know, that kind of confused me from what I learned in like business law.
I guess it really depends. It could be enforceable on their heirs.
yeah, that's what he's saying, yeah.
Yeah.
That's what it said.
Yeah. So if you're gone, someone's got to you're still under contract.
Yeah.
Is Justin in there?
No, he's in the other room.
Yeah, he's out there.
I'm gonna ask him, because I'm actually kind of curious about that.
Yeah, that'd be interesting. I'd like to know myself.
Yeah.
I haven't had that happen. God forbid it happens to any at all.
That'd be my luck.
Yeah, that would be Justin's luck, honestly. He's got the worst luck. Yeah, so if I die, it doesn't really matter if the broker dies. It would terminate everything. Same with the principal as well. He's asking him now to see what he says. But yeah, if I go bankrupt or I'm condemned, if the property's destroyed, then we would terminate the agency with that. So confidentiality continues forever. Forever. So it doesn't matter how long it is after I'm done with this client. If I was given any confidential information whatsoever, you can't disclose that. You can't tell anybody. So that continues throughout your life, any of your clients. But you may disclose it if that client gives you consent. I don't know in any situation a client would give you consent to give away confidential information, but if the situation arises that you do have consent, then you can actually do that. But if not, just know that confidentiality is going to continue forever.
That does have to be written consent, correct?
Yes, it would have to be. It would have to be in writing that they said I can disclose such and such.
Okay, I have an answer.
Oh, we have an answer?
Yes. So basically, if somebody passes away, the principal in the transaction, it goes to the estate, which usually means it's terminated because it will go to the government. Since the state has it, they're not going to do anything with it. But what Justin was saying is, however, in real, like as far as the test goes, it's terminated.
Yeah.
But he was saying that because it goes to the estate, technically, like when my dad passed away, if we were in the middle of a transaction, it would go to my brother because he's technically the yeah, like he has the power, what's that called?
Power of attorney?
Well, not power of attorney, but basically he's the one in charge of the will and everything like that. He has the estate, so it would transfer over to him in real life. But as far as the test goes, it's just terminated because usually the way they put it is that if it goes to the estate, it's actually technically it's going to the state that holds it at that point, and then the contract's dead. So as far as you wanted to know, it's dead. But he was just saying that in real life, there are situations where it could pass on to heirs, but usually that's not what.
Well, I guess it just depends.
Yeah.
But yeah, usually if the client dies, I guess
It's terminated. Yeah.
Yeah. So if I was given consent, I would want it in writing. Otherwise, I still wouldn't say anything. And even with consent, I can't think of any situations. I mean, I'm sure there's situations that arise where I could give away your confidential information, but
There's no reason you really want to.
there's no reason. Yeah, there's
Yeah,
really no
so-
reason you would want to.
I'm not gonna search you out just to see if I can give away your financial situation to someone. Like that doesn't make sense. So it's
Yeah,
like, usually
that
it
makes
just
sense.
yeah, it just stays confidential.
And there's an example in your textbook if you want to look at that. It's on page 249. All right, another shorter class. Our key points for this evening, and then of course we have a few discussion questions like we've been doing. So payment of a fee is not necessarily, it doesn't necessarily create an agency. So just keep that in mind. When creating agency, you can either do it by express. There's implications to that. You can also do estoppel or an extensible agency. Agency by ratification. You can do it with or without writing, but do it in writing. So the broker acts as a fiduciary regardless of how agency is created. The licensee can be an agent and not know it. So like I said, your actions can lead to agency. And you may not even know that this person thinks you're their agent. If the consumer thinks they are represented, the courts will generally hold the licensee liable. So if the consumer thinks they're represented by you, you're represented by you, pretty much. And the courts will judge that.
Everything is always in favor of the clients. So
Pretty much.
if they are under an assumption, that's usually what the court will take into consideration more than you being like, well, technically I never gave them, but like they'll usually take their side. So
So agency can be terminated by mutual agreement or rescission. It's unilateral. like renunciation or revocation, expiration of time if it expires or terminated, abandonment by the agent, and operation of law. Also, customer and client, we've gone over the distinction multiple times. They're both owed accurate information and facts, but of course the client is going to get your advice as well and your opinions. Suggestions for broker. Develop company programs clearly stating office services. We have office services. We have a whole form with all our services, and most offices are going to have that as well. An office policy, report any variations in the office policy immediately. All right, discussion question 1. What do we got online? Look at Cody. Just chilling. You want to answer this one, Cody? How about that? You want to do this one? So why doesn't the fact the seller pays the broker a commission necessarily make the broker the agent of the seller?
So my guess on it would be you didn't go into a listing agreement with the seller. You pretty much don't know the seller. Typically, the agent doesn't contact the other party's client. It's usually just communicated between agents. So I guess my biggest thing is you don't have any type of contractual listing agreement with them. You have one for a buyer, and you are the procuring cause of giving them a willing, ready, and able buyer for the sale of the property.
Exactly right. Very good. Usually, like I was saying, the seller will pay the commission. So just because I'm getting a commission from the seller doesn't mean I'm necessarily representing them. It can be representing the buyer. So very good. Question 2. How does the concept of constructive or inputted notice affect negotiating in a contract? Let's see. Carwan, you got a bunch of questions today. You got any answers for me? Huh? I'll let you do this one.
There we go. How does the concept of constructive imputed notice affect negotiation of contract? Well, it's for constructive notice, I'm assuming it's more.
Remember, constructive notice is if I am told something as their agent, then my client automatically knows about it, or my client should automatically know about it. So how would that affect negotiating?
It's more straightforward.
Okay.
Okay. And imputed notice is more indirect.
Okay.
I don't know, I can't go into details, but those are the differences.
Okay. Very good. So if I'm given notice for anything, my client's automatically going to know. So the other party is automatically going to think that my client knows, even though they may not know. If I didn't tell them something, they may not know.
Mm-hmm.
So
It can, I was saying, it can make a negotiating either really quick because there's not emails going all over the place. It's more like the agents just email each other and then just kind of will talk on the phone with their clients. So it makes it a little bit faster, I think. But it can also make it more difficult because, yeah, if I'm a buyer and I send over an offer, they send a counter offer, and then I don't know they sent a counter offer because my agent never told me they sent a counter offer. He's out of town, he doesn't tell me for a week. Well, then he finally tells me, so I say send this back, and he sends it back and they go, well, you took too long. And I'm like, but I just heard about it yesterday. When in reality, my agent heard about it a week ago, and so I should have known about it a week ago. So yeah, it can get confusing and it can make things a little more complicated sometimes if you're not on top of things.
Yeah, just as soon as you learn something, tell your client.
Yeah.
Because they're supposed to know anyways. So very good. Question 3. What actions or conduct performed by a salesperson would lead a court to decide that the salesperson and his or her broker are the implied agents of the buyer? Let's see. Ms. McKenna, you want to do this one?
Sure. Wouldn't an example be if an agent takes them to look at a house?
Exactly
Not
right.
anything.
If I show you a bunch of houses and the client thinks that I'm your agent, even though we haven't entered a contract, then yeah, the courts would probably rule in favor of them. Very good. That was a bit of an easy one. So I'm going to pick the hard one tomorrow, and you got to do that one, okay?
Oh no.
Oh, come on. You want to do it?
We'll see how I'm doing tomorrow. We'll try.
Sounds good. All right, so we got one. Actually, never mind. We got 2 more. What are some of the distinctions between the duties owed to a client and those that are owed to a customer? We've talked about this multiple times. Gio, were you paying attention at all?
I mean, yeah.
Okay. You want to do this one then?
Yeah, I guess. Like for the most part, just like certain like you can't advise them of like certain things as far as like the price on the game side. I guess stuff like stuff that you can't just disclose. So like that and like the lowest bid or like the lowest offer they'll take something like that.
You got it. So remember that if they're just a customer, they're only given facts and you can't give them advice. So yeah, if you have a client that they're actually owed, you would give them more than just facts. You would also give them advice, stuff like that. So very good. All right, last one for the evening. How do the fiduciary duties apply to an agent when selling a house to a close relative of the agent who is not collecting a fee or gratuitous agency? So how should I treat, if I know the person, or as I'm a close relative to the person, how should I treat that person? Should I give them special treatment, anything like that? Let's see, what do you think? Cody, you want to do this one too?
Sure. So no, you can't necessarily give them special treatment. You still need to disclose that, or wait, no, never mind. You can also, like, I think if I remember you stating that court case earlier, Keller versus someone about something similar to this.
Yeah, you got it, man.
A little bit earlier. The court is still going to see that you have an agency relationship, regardless of your personal relationship with the, I guess, client. They're still going to rule that you owe your fiduciary duties to this person. You still need to be honest, or old car. All that is still going to need to be applied to this person as well, is what a court would rule.
Exactly right. I cannot give someone special treatment just because I am related to them or I know them. Actually, if you're in a transaction and you know the person that you're actually dealing with, there's actually a whole disclosure form for that, basically saying, hey, I know this person, but I also agree not to give them special treatment. They gotta have the same treatment that I would give any other client. So very good, Cody. All right. Well, that covers our lecture for this evening. Go ahead and stop the recording. And before y'all go, we need to tell y'all something.